Hello?
Hello, is that Mr. C?
Yes, it is. Hi, is that Sian?
Hello, yeah, it's Shaw from the Ombudsman. You okay?
Yes, I'm okay. Thanks for calling me back.
Not a problem. So just before we go back into your template, Mr. C, just confirm some security questions with you.
Okay.
Thank you. Just confirm your email address
Um, fatabegum@gmail.com.
Thank you. Your full name
Mr. Sajjad Hussain.
and the solicitor that the complaint's against.
Burke Niazi Solicitors.
Brilliant. Thank you very much. And just as a reminder, as you know, all calls are recorded, but mainly for quality and feedback purposes. Okay.
Okay, all right. Yes, I mean, yes, that's fine.
So, listen, I popped you an email last night, just a reflection and confirmation of our discussion.
Uh-huh.
But really, what we just need to do today is confirm what complaints that we're going to investigate and take forward, and then I'll look to speak to the firm, get their comments, and we'll see where we go from there. Okay?
Yeah, that's fine. I mean, we spent a considerable amount of time yesterday just discussing the issues regarding disclosure, which I explained was the lesser issues of complaint. And you've advised me regarding, obviously I've informed you that that's being looked into by the Information Commissioner's Office. But also, from your perspective, I was looking to say that this was a service delivery issue where there was lack of transparency. You informed me that you can't really investigate like high level stuff like transparency and issues like this. But however, you would look to ask for specific questions, look to have addressed. And one of those things that you've highlighted is that, like for example, if I want cost analysis disclosure, that would be something specific, and so there have to be specific terms that you would look to resolve. And so I think we're on the same page.
Yeah, I think so. I think we did have a long call yesterday, and I
Yeah,
think we did discuss everything, didn't we? So
yeah,
kind of to see what we can look into, and,
yeah.
what points we can look into for you. So really, it's just about picking out the points
Yeah.
that we need that you
Okay.
want us to investigate, really.
Okay, all right, that's fair enough. I mean, obviously, the far more serious issue that I wanted to discuss with yourself. Obviously, I've had to report this matter to the police, and I've forwarded that to yourself. And as you can appreciate, if and some of the things that we discussed yesterday, lightly touched upon, is that if there is, like, for example, through your investigation, you find that these are the issues that, because ultimately, as an ombudsman, you're looking to find a resolution that's both satisfactory to both myself and the other party. So, like, as a middle ground, which would be obviously, you're not your job is not to draw like criticism or blame on anybody, and I understand that. But however, I have to look at, I mean, that's your limitations of your role. However, I have to look at the wider picture and know that yes, there are times when things can go wrong, and but under these circumstances, I feel the fact that it's serious enough to warrant it be coming to yourself. So there has to be some serious breakdown in relationships, and those are caused, and the cause of those can either be some sort of systemic problems, such as that are outside of the control of the organization. But ultimately, what my argument is that these are as a result of malevolence. Now, if it's an issue of malevolence, first of all, you as a third party can't make that judgment call. However, that's the position I stand upon. And also, if you were to establish that it's part of malevolence, there's nothing you can do about somebody deliberately doing something wrong or criminal or fraudulent, is there? So that's where I think you and I are on a different have a difference of perspective. Where I believe the actions that are perpetrated by the organisation are deliberate and through malice and malevolence, and so therefore, coming to yourself, it would be unreasonable expectation upon myself to say that, look, they're acting malevolently, do something about it. And I understand that that's not something that your role is committed to, but I do understand that you do have a powers of you have certain powers to penalise the party that I'm complaining about. I just wanted to confirm that that is limited to, I think, is it £50,000 as a maximum, as a penalty notice under that's the most severe, the most severest outcome that can be asked of yourself. I'm not saying that would be the case, but can I just confirm that is the case? that the coming to the Ombudsman, that you do have powers to require the other party to pay a financial penalty, but that is limited to £50,000. I just read that somewhere. Is that correct?
Yeah, that's correct. I think I don't know if I sent you the copy of our remedies guidance. I think potentially yesterday.
Yeah.
But yeah, that is correct. That's our limitation as an organisation. Obviously, they're rewarded as a really exceptional reward.
Yes.
If there's been long-term impact on the customer's kind of well-being or life. So, you know, like it is a rarity, but that is a limitation
Yes.
of what we can offer in terms of compensation. But the compensation is a reflection of if we find poor service.
Yes.
And what we think that poor service is. Sometimes that can contain, fees that have been paid if private fees have been paid, or, emotional distress, or, emotional impact if something is long term. Just to go back to your first point about, what can we do to penalise it? The compensation is not necessarily to penalise them. It's what we think customers should have in recognition of the poor service. I think in terms of conduct, potentially what you're discussing, then that is something that the SRA would look at. So that's the Solicitors Regulation Authority, and they're the governing body over solicitors.
Mm-hmm.
They look at more issues of conduct. If there's serious breaches or negligence in conduct, then that's something that the SRA investigate. What we look at, and which is what I think you've got a really good grasp of, is service complaints. And really, like I said, we try and act as a middle person to get a suitable resolution. We can't always do that, and in that case, we'll reach our own finding and make a suggestion of compensation, which we can enforce if we make that ruling by a final ombudsman.
Okay, I think at this stage it's important to manage expectations, and I think that's clear to me. Obviously, I don't believe that the outcome that I'm going to receive from yourself, irrespective, is going to be the outcome that I'm looking for. So that at least manages my expectations, because I then know what the full scope is. Because obviously that gives me an opportunity to pursue other lines of grievance, namely I can go to the Solicitors Ombudsman Authority, or Solicitors Conduct Authority, or I can take my own private issue, the private prosecution. So that at least gives me the clarity. So thank you for that clarity of understanding. Now just moving on to the more serious issues, like I said, even though some of the things that I explained to yourself that they may not be within your scope of inquiry, like for example I was explaining that they're not dealt with the subject access request appropriately, and you've informed me that that's not something that it's that you would be able to look into further, simply because that's something that a different organization looks into. Now I understand that, but equally it's important for me to explain fully, so you have the full depth and breadth of what's been happening on all my grievances, because even though the subject access request is not something that you would be looking into as a formal complaint, it does play into the aspect of delivering a post service, and this may be like an aspect of the larger issues at hand, which are maybe complaints. Now, one of the things that we discussed yesterday was their failure to start initiating services, because I first contacted them in April. So I just wanted to pick up from there regarding not looking at the disclosure issues, but just looking at the failure in service delivery. So what happened was that, just as a bit of a background, there was a final hearing in the Court of Protection on the 15th of February to the 19th of February, a hearing that I had not attended. I was not legally represented at the time, and the outcome of that hearing was that I was to vacate from the premises where my mother resides, so that was one of the issues that was outcome of where the local authority would look to take charge of the care and support under the authority, or the authority that they had secured. So that was kind of a really malevolent issue instigated by the local authority. Now, there was two outstanding issues at that hearing. One of them was obviously following that hearing, one of them was to review the care package that the local authority had provided, and further, so the courts were interested to know, if there were any other issues outstanding. And the other issue was they had injunction orders in place where they said that there's a penal notice, and therefore there were committal proceedings. So in the hearing in February, there were also concurrent committal proceedings. So basically, that's what the situation was in February. Now, I obviously at this stage were looking to. I had previously been always representing myself, and my intentions were to always represent myself. However, one of the conditions placed was there was restrictions placed upon me to engage with the court process or the make further applications, and at that stage I thought it necessary, or I was left with no alternative but to seek legal representation. Now my understanding was that irrespective of which solicitor I get, from my own personal experience, and that's something that you don't need to agree with, but my personal experience has always been that irrespective of which solicitor I get, the local authority, because they've got a personal vendetta against me, would always look to procure and malevolently secure the services of my solicitor. That's happened in the past, and hence why that's justified why I would always refuse to get a legal representation, because under my unique set of circumstances, it became apparent to me that irrespective of which solicitor I got, I would always end up in a situation where the solicitor would be working against my interest and working effectively in the interest of the local authority. That is something that I had experienced numerous times in the past, which is outside the scope of my discussions with yourself. But that I'm just basically trying to explain to you that was my position, hence why for over 3 years I had refused to get a solicitor. I was left into I was railroaded into a situation where I needed to get a solicitor now, because my contact with my own mother was being restricted, and there was and most importantly there were injunction, or what's the word? I was basically facing imprisonment. Because they had stated that I had breached the notices, and that was still ongoing. So there were committal proceedings. So because I'm entitled to legal aid and there were committal proceedings outstanding, I then sought to get a solicitor, and I did that by first of all approaching barristers myself. And the barrister I had approached advised me, because I've got there is legal aid funding available, that I should get a legal aid funded solicitor, and he himself made the recommendation for Burke Niazis. That's how I ended up in contact with Burke Niazis to start with. As you understand, that the first time that we had a communication was on the 1st of April 2021.
Yeah.
Now, one of the first things I did make to the solicitor was, now I know about how the legal process works, so I was primarily keen on securing the solicitor, because I've spoken to the solicitor and we've had something in an informal chat does not mean that I've secured their services. So for me, the priority was to secure their services, because at that stage I would then be in a better position to relay my concerns or seek legal advice. Now, so when I first contacted the solicitor, and he had asked for a brief description, I gave him initially clear instructions not to contact the other party. So, at this stage, until his services had been secured, not to contact the other party. Hence why I've gone to this tirade of explaining to you that I feared that by communicating with the other party, the solicitor would effectively be in a position to be bought off or services compromised. So that was the very first instructions I gave the solicitor, not to contact the other party. First of all, let's just get your services secured with. I think within a couple of days, he contacted me back saying, I have contacted the other party, and I've got some good news for you, that the committal proceedings, the local authority are not looking to pursue the committal proceedings. So, having taken instructions from me, having not received, secured the services, quite earlier on, I think about the 8th or the 9th of April, he had told me that he's actually contacted the other party and got it cleared from them that there would be no committal proceedings. Because as you can appreciate, that there are two forms of legal funding. One, if there's committal proceedings, that funding is, the solicitor explained to me, is less restrictive. So they don't need to make the process is much easier, because effectively you're facing prison time. So the legal aid application is easier on the committal proceedings rather than the other legal aid for the court proceedings, because that requires means testing and so on and so forth. So although it was good news for me, it was obviously not very good news for the solicitor, because obviously there was an aspect of money basically that they would not be getting. So at the early stages in April, it became clear to the solicitor that there would be no committal proceedings taking place, and that there would be only these ongoing court protection proceedings. So obviously, once again, that was not a really issue for me. That was obviously like, yes, that's good news. But can we just get on with the fact that, to secure your services? Simply because, and I was kind of disappointed that he had contacted the other party. So I did raise that with him. And he said, look, Mr. Hussain, at the end of the day, I'm a solicitor and it's necessary for me to speak to the other party. That's only I did it. I was acting in your best interest. And that's why I contacted the other party. Now, as you can appreciate, there's still ongoing court protection proceedings. I'm not going to be focused too much on what his conduct of not contacting the other party. Obviously, the main focus was to secure his services. Now, what had happened was that, but there were also because the court proceeding was still ongoing, and the local authority had sent in a report stating, making certain allegations. Now, so I needed to respond to that. So I quickly responded with that. At this stage, I think towards the middle of April, because obviously I needed to secure his services before I responded, but he was not forthcoming to have his services secured. So I responded to that issue that was raised by the local authority. Basically, what happened is that the local authority had said that we've come into the property as in a dilapidated state, and we're just making unfounded allegations regarding the quality of the premises that my mother was residing in my care. However, what I had done was I had video recorded everything before I left, put it onto YouTube, and what I did then was, in order to respond to legal questions or the legal issue now being raised, and the solicitor services not being secured, I then proceeded to send that video over to the other parties. Now, what's happened is that as a result of the solicitor's failure to secure the services or give me advice, that's triggered a further injunction violation. All right, and that injunction violation, basically there were transparency injunctions in place that I should not publicize the case, my mother's case. But this video was not in order to publicize. It was placed on YouTube in a private place, so just basically to respond in evidence. So I was wanting to use it as evidence. So now the other party, even though when I had approached the solicitor and the solicitor had contacted the other party, the committal proceedings have been withdrawn. Now, as a result of the solicitor's the lack of securing the solicitor's advice or services, I had done something which had then resulted in further committal proceedings now initiated. All right. So then when I told the solicitor, look, because you've taken such time, now there's further committal proceedings. So now can you see the fact that the solicitor whom had initially spoken to me at the start of April, where he had realized that he was not going to get money for committal proceedings, now all of a sudden, because of his failure, he's effectively financially benefited, because he was not able to advise me in time, or I could not seek his instructions towards the middle of April, I had now effectively committed what the other party was saying was another violation, which obviously the solicitor was then made aware of. Even at this stage, when I told him, look, they're now saying that there's another committal proceeding going to take place, so there's a risk to my liberty, and can we please get on with securing this legal aid funding? So towards the end of April, he had asked me for the information I had previously given him, like my bank statements. He had to ask for that information once again, and I was quite eager to have his involvement, because obviously I now stood effectively facing committal proceedings again. So I was very patient with him and provided him with all the information. And at this stage, conveniently, he said he went on holiday or something. Now, the next hearing was listed for the 12th of May. Now, by the 12th of May, a couple of days earlier, I informed him that, look, there's another hearing coming up now, and I'm still waiting for you to secure your legal aid funding. And within days, I think 2 days beforehand, he had put in the application. So effectively, what it had meant was that on the hearing, where on the 12th of May, I think, I was once again having to represent myself at committal proceedings. I obviously informed the judge that, look, I do have legal aid funded solicitor whom is still looking to secure the legal aid funding certificate, and so therefore I had asked for an adjournment. I believe that was agreed upon, because obviously the judge was quite keen for me to be legally represented as well, especially through committal proceedings. So obviously that was adjourned, I think, towards the end of May. And so I think, like I said, I don't have the dates in front of me, but that was adjourned. And then subsequently, following the hearing, which I had attended in person, where effectively I had no legal representation, even though I had contacted the solicitors at the start of April. At this stage, the solicitor said, "Yes, we've got we've got now legal aid funding, and we'll be looking to represent you." And then gave me an opportunity to speak to the barrister, because effectively I needed some legal advice regarding the barrister. And as you can appreciate, there are many concurrent things going on. This at the time was a lesser priority for me to deal with the solicitor, because ideally if they had done their job properly, it would not be really been an issue, it would have not been a taxation on my resources. However, they had been very lethargic about things, and I feel the fact that when I contacted them and they had contacted the other party, there were no committal proceedings, and so therefore, because of their failure to act promptly or within a quick amount of time, had then resulted in committal proceedings once again being issued out. And therefore I felt that the solicitor was responsible for that, and I made it quite clear to him that that was his fault, that he had not got back to me in time. And so therefore there was a kind of an animostic relationship, because I stated that because you have failed, I'm holding you responsible. And he said, "It's not my fault, because you hadn't provided some documents." And I said, "No, I actually did. I provided all the documents quite promptly, as was required of me, and it was a failure on your part." So that's the first basis of the complaint that I had initially discussed with you yesterday, that as a consequence of the substantial delay of nearly 6 weeks, that had not only resulted in a failure of service, that obviously resulted in new committal proceedings being instigated against me, in conjunction, after having it established by the solicitor, after I told him not to contact the other party, contacted the other party, and I confirmed that there would be no committal proceedings. Now, because of the delay, substantial delay, therefore placing me in a situation where I had to respond to legal, court statements within a time period, I responded, because and that then resulted in further injunction, so further committal proceedings proceeding against me. So I made it quite clear to the solicitor I hold him responsible. Subsequently, after the hearing, I think there was a further hearing where the solicitor and the barrister had attended. Now, the barrister in this question, I remind you that I had selected a barrister myself, personally, who had advised me to get a legal aid funded solicitor. So obviously, I was quite keen for this solicitor's firm to go back to the same barrister which I had selected. However, the solicitor felt that he had a more appropriate person to deal with this situation, which was his preferred solicitor. So he had basically put me into a situation where I was required to take on his preferred solicitor, whom he had worked closely previously with. I feel that's a further issue of complaint, is that I, as the client, should be in the one deciding who the barrister should be, and I had already made a selection of my barrister, but he had basically effectively not given me the choice, but had selected a barrister that he was feeling more comfortable with, and that was basically he wanted to work with, rather than that barrister that I wanted to work with. So this barrister had then come on board, and then, as you can appreciate, that I had only spoken to her minutes before the second hearing in May. You're going to have to forgive me, because I'm trying to recall everything off my head a year ago, but I think there was a second hearing. I did speak to her minutes before the hearing, and basically they were just saying that we want an adjournment for the committal proceedings until the 5th of July. We've just come on board and we need some more time, and so on and so forth. So it was at that stage, after the second hearing in May, that I obviously had the pressure was off, basically, because now I had a legal aid funded solicitor. I had there was a barrister that I can seek advice from. So at this stage, I think towards the end of May, I started to I started to ask for legal advice. And one of the as you can see speaking to me, I'm very clearly articulate. I made it quite clear, this is what I'm looking for. I want to appeal. I want legal advice on appealing the court hearing decision in February, where I was not legally represented. I did not attend the hearings. This has adversely affected both me, my mother, and my family members' human rights, where we are denied access to our own mother. And so basically, that's one of the things that I want you to assist me with, to appeal the decision. And second of all, I would like you to assist me in having some contact with my mother or some provisions in place, in addition to defending me in the committal proceedings. The committal proceedings seem to me like an afterthought, because as I explained, the committal proceedings were initially supposed to be done in February, and then subsequently, because they had not been done, and then when the solicitor contacted them in April, they said, yeah, no, the local authority said, we're not going to pursue that anymore. So those committal proceedings were a different issue. So the new committal proceedings were all to do with an incident that occurred in April after I had approached the solicitor. So the new committal proceedings were, I understood that they lacked all legitimacy, and it was something that I felt confident that I didn't even need a solicitor to defend. It was just basically a malicious committal proceedings. But obviously this meant that the solicitor could now get more legal aid funding on my behalf, because obviously he had two sets of legal aid funding now, one for the court of protection proceedings and one for the committal proceedings. And so it was in his interest, I feel it has been in his financial interest for the delays. But anyway, so they have selected a solicitor, a barrister, for me. I explained the situation. I said, these are the things I'm looking for. And furthermore, what legal advice I want is that, what are my options when I believe and understand that the senior judge in this case has had his services privately commissioned out by the local authority in order to railroad through a nefarious agenda. Basically, I was stating that the judge is corrupt, and that's a complaint that I had been making to the solicitor, that, look, what are my options? What can I do when effectively the judges are, sorry to use this term, but what I was saying to them was that effectively the judges are prostituting out their services to the local authority, and that's what I want legal advice upon. And obviously the solicitor was saying, no, they wouldn't be doing that. They get paid a lot of money. They wouldn't. And I said, irrespective, that I had quite a confrontational conversation with the solicitor. I said, what assurances can you give me? What effectively stops a judge from selling out? Because politicians sell out and everybody else. Corruption, just because you're a judge, does not make you immune from corruption. And so therefore I was having these arguments with them, and as a result of then insisting on receiving legal advice from them, I believe that obviously there had been some collusion by the solicitors and all the other parties. So irrespective, they had then come back to me and said that, well, we feel that you lack litigation capacity, all right, because of these allegations that you're making. And I said, well, okay, well, if I'm making allegations, please, I'm quite averse now in the Mental Capacity Act, because I then said, look, what is the cause of my lack of mental capacity? I mean, obviously, I don't have any medical conditions. I told them about, and obviously, they are fully versed in the Mental Capacity Act, where an assumption of capacity must be assumed. So I tried to challenge them on this, and then, they were like, it just seemed to me that this is something that they had been commissioned to do. So, because obviously they no doubt would have liaised with the judges and everybody else, saying that, look, our client is now saying that there's this corruption. So I believe that was orchestrated or contrived to my detriment by my own solicitor and barrister, who were effectively saying this thing, that I lack litigation capacity because I was making some very serious allegations. And I said, well, that's nonsensical, because obviously I have the capacity to retain information, and I was trying to evaluate that information. Now, I may be deluded, that may be correct, I may be mistaken, but for you to make the very serious allegation that I lack litigation capacity, all right, at the time, it was unclear to me what outcome they were looking to achieve, which obviously came transparent over time. But at the time, they're saying, no, we think you lack litigation capacity. So it's at that stage that I told the solicitor, Michael Barrett, that, look, you're making a big issue here. It's a big complaint, and I don't want you to be making this decision unilaterally as a solicitor. Having taken advice from the barrister, please can you escalate this matter to your senior management, because this is going to be a complaint, because I'm your client and you're basically saying that I've got a barrister, and the barrister saying that I lack litigation capacity. She's not an expert, you're not an expert, all right? And I feel that something, so it's at that stage that I understood like that something malevolent was taking place, and I advised the solicitor to escalate this matter to senior management, your senior management, so the fact that this is an issue that I'm going to be looking to challenge you upon. But irrespective, the solicitor was saying, At this stage, I started asking more written questions, hence why our conversation yesterday, that look, I asked written questions that they would fail to respond to. So at this stage, the communication becomes very restricted, basically, my agenda, which I've explained to you, was quite clear. Have the appeal challenged, have an appeal of the hearing in February, look to gain access to my mother, and obviously look to defend any committal proceedings. Now the agenda seemed to have all of a sudden changed to my detriment and to the solicitor's advantage, because they then started saying that, obviously we're in a grey area. So when they went back to in the courts in July, they had stated they had to make the courts formally aware that they felt that they could no longer represent me because of concerns regarding my capacity. So I advised them not to do that. Please don't do that, all right? Because putting me in a worse situation. And also around about this time, the solicitors were aware that they had to make a formal response to the parties in the courts by a particular date. All right. So when I spoke to the solicitor that week, and I told him, you're going to have to forgive me around about the dates. I think it was sometime in June or something, that middle of June, that the courts had ordered me to submit a statement by a particular date, I think a Friday in the middle of June. I had spoken to the solicitor on a Thursday, and I said, look, and I reminded him, look, you're now legally representing me. You know the fact that there's supposed to be a statement submitted tomorrow. So can we discuss this? Because there was many other things going on, and he said, no, don't worry about that statement. All right, we'll deal with that later. But so he basically fobbed that over. So there was a court order requiring me to make a statement by a specific date. The solicitor I had legally represented, a legal aid solicitor, Burke Niazi solicitors, Michael Barra, and he had not complied with the court order. All right, and he had not submitted that statement on my behalf. And so when I spoke to him the following week, I said to him, look, you were supposed to submit this court statement from me. You didn't even take down this statement. So what's going on here? And he said, well, I can't take down your statement. And after the event, he's stating that the reason I could not take down your statement is because I feel that in the previous call, you had made certain allegations which led the barrister to believe that you lack litigation capacity. But so that's the reason that he didn't submit a court-ordered statement that was required of me. And I said, well, it doesn't matter. You should have still submitted a statement stating that to the courts. So, for example, let me just slow down here a little. The courts had ordered me to submit a statement by a particular date in June, I believe. The solicitor at this time, whose services I had secured, had failed to do so or notify notify anybody of the failure to submit that statement. And then when I spoke to him a week later, he said that, the reason I didn't submit the statement is because I believe that you lack litigation capacity. So my argument was that whatever you believe, that's irrelevant. Because if that's what you believe, an opportunity was afforded to you to make that statement to the other parties. If there's a court order, a direction from a court order, you have to do that. You've not done that. And now you're making excuses saying that I lack litigation capacity. All right? So that's where obviously it's become quite contentious. Because he's saying that I lack litigation capacity, and I said, I want to speak to the barrister again, get clarity of why she is stating that I lack litigation capacity. So we had a quite lengthy conversation, and it seemed quite apparent to me at the time that both the solicitor and the barrister were having their services commissioned out and acting against my best interest. So obviously alarmed and distressed, I sent several emails, and you have to take into consideration that I don't know who the senior management is at Burke Niazi, but I did advise the solicitor, look, don't make this decision, don't tell the courts that I lack litigation capacity, because that will place me in a very precarious situation. Can you not do this? So I emphasized the seriousness and the distress I was feeling. However, he said, he at this stage started saying that, well, no, I have a duty to the courts, and I'm going to override my client privilege or whatever, or my duty to the client, because my duty to the courts overrides my duty to the client, and I need to make them aware. So the hearing of the 5th of July basically had been hijacked once again by my own solicitors in order to inform the judge and the courts formally. all right, through the court process, that they felt that they could not represent me because of they felt that there was a lack of litigation capacity. So on the 5th of July, the judge, obviously given those facts, had to make further adjournments in order to be satisfied that I did not lack litigation capacity. So then that's hence why the judge had ordered the hearing to be adjourned till the 2nd of October later in the year, to give the solicitors ample opportunity to get further legal aid funding in order to secure a mental capacity assessment. So now you see the agenda's completely changed. All right, now the solicitors and the parties and the courts are looking to prioritize getting a mental capacity assessment carried out. And so on this occasion, I'm just thinking, how are they going to select? So then there was an issue of who was going to carry out the capacity assessment. That should have once again been agreed with me. There was something quite dodgy going on, because all of a sudden a court order, so let me tell you exactly what happened. The court on the 5th of July could only make a determination that yes, an independent party should carry out a mental capacity assessment. However, when the order was received by me, it had already stated who was to carry out the mental capacity assessment. So at that stage, I raised this with the solicitor. And I said, look, okay, we've gone to court and you've raised the issue of my lacking mental capacity. The courts have agreed with you. But the courts had not, on the 5th of July, selected who should carry out the capacity assessment. So can you explain to me why an order dated the 5th of July now states an individual's name? Because my understanding was that, it would have been, basically, it was quite quickly rushed through. The court order on the 5th of July had made no discussion of who should carry out the capacity assessment. And so what I wanted to determine is that if everything is legitimate and, the courts have ordered you to now carry out a mental capacity assessment, then quite clearly there is a procurement process where you would obviously look to tender that as a contract, look to secure numerous availability of who's available, who can carry out this assessment. I said, did you do that? And he said, yes, I did. So I said, provide me with evidence of that. Because, do you understand, it's a chicken and egg situation. On the 5th of July, an order dated the 5th of July, which was received by me towards the end of July, quite clearly has selected somebody. And yet you're telling me, so when did you select somebody? Because quite clearly, so now I try to challenge the solicitor, saying that, look, if you had selected somebody, that selection process could have only commenced after the hearing on the 5th of July. And also, the selection process, it would have been whittled down, who's available, who's not available, who are all the other people that you contacted? And he said, no, I did contact other people. And I said, well, give me that information. Hence why I think I made the initial subject access request, because I wanted to know, who. I said, so I kept on asking those written questions, all right, fair enough, I'm going to go along with this fraud on deception that you're telling me, that on the 5th of July the judges ordered that a mental capacity assessment should be carried out. On the hearing on the 5th of July, which I did attend, no mention was made about who should carry out the assessment. And now all of a sudden I've received an order dated the 5th of July, stating a particular person. So I wanted to know, had the solicitor, because from my perspective, I knew, obviously I can't prove malevolence, but I know the solicitor previously had contacted the local authority, and no doubt this capacity assessment was not selected arbitrarily. It was selected quite selectively, and I believe that there was a conflict of interest if the local authority had selected the mental capacity assessor. But however, I felt the responses given to me by the solicitor were, first of all, not transparent, very, very evasive, very, very dismissive, saying, no, you must trust us. So ultimately what I was being asked by the solicitor is saying that, trust me, I'm a solicitor, and therefore everything I am doing is above the law and cannot be fallible. And I said, well, that's a ridiculous position to hold, because I'm saying not only you, but also the judges are having their services prostituted out. So at no point during my engagement with the solicitors firm did I not believe that their services would not be privately commissioned out. However, I can't just make that allegation. I needed evidence. As I explained to you yesterday, I'm an evidence-based individual. So therefore, I needed to have evidence that actually, yes, they had their services commissioned out by the local authority and were effectively utilizing me as a legal aid mule in order to get funding, my legal aid entitlement for funding, in order to pursue an agenda that was not in my interest, but in the local authority's best interest. So obviously, when I started questioning written questions like, all right, give me this information, you should have tendered that as a contract for potential mental capacity assessors. You should have then whittled down one appropriate person, and so the mental capacity assessor that they had chosen, all right, which had been already on the order, was somebody that would later. Once again, the court had ordered that the capacity assessment should be done by a particular time, so well ahead of the hearing in October. So I think the court had ordered that the capacity assessment should be carried out by, I think, end of August or something. And yet come July or August time, the solicitor was not communicating with me or not answering my calls. And so while this was a live issue regarding myself, regarding potential committal proceedings, regarding my own mental capacity, the local authority, in collaboration with the clinical commissioning group, had sneaked in a vaccination application. But yet here I am, not in a position to deal with that vaccination issue, because the priority for me now is to deal with this new issue that the solicitor has raised regarding my mental capacity. So I'm trying to communicate and trying to talk to him, say, look, talk to me, I need clarity of understanding. It's very, very frustrating. And then obviously the aspect of the CCG's CCG's application for the vaccination was a less priority for me, even though it was very serious, because what I needed to do was I needed to have clarity of understanding from the solicitor. Now, what vexated me and frustrated me is at this stage, the solicitor was fully funded. All right, he had legal aid funding, but he then kept on complaining to me, saying that there's not enough money for us. There's not enough money here. So, and I said, how much money are you making, and how much money is a barrister making? And he kept on complaining to me that, the legal aid funding for not the committal proceedings, but these other proceedings, there was not enough money there, and so on and so forth. So on the one hand, he's complaining to me that the justification of him not speaking to me on the telephone or giving me this information is because he feels that there's not enough legal aid funding. All right, but I said that's nothing to do with me. If you're a legal aid solicitor's firm, if you don't feel that the legal aid funding is adequate to meet your needs, then don't take on this case. All right, you can't be cake and eat it. And so therefore, his explanation, like I said, it was very, very evasive round about July and August, because July and
Sorry, listen, just let me interrupt if you don't mind for a second, because obviously we're 40 minutes out. I need to confirm your specific complaints. So just to double check there, so let's just recap as to what your actual points are. So there are a couple of things there that I've picked up were key issues for you. So one of the complaints would be that the firm made the legal application until 2021, 6 weeks after you instructed the firm. So am I right in saying that's a complaint point that you wanted us to investigate?
With respect, I can only give you the background. It's upon yourselves to pick out what other complaints. Yes, that would be a complaint, yes. But I don't know what meets your criteria. All I can state to you at this stage is what was happening and what had happened. So that is a point of complaint. The other point of complaint is that if I had given written instructions to the solicitor's firm, why had they not followed those instructions? So one of those instructions, because obviously if I'm going to be instructing the solicitor and I tell them on the telephone and they don't listen, they can say, well, no, there's no evidence of that. But so one of the complaints I would like to highlight is that I had given written instructions or verbal instructions to them. One of the very first instructions I told them was not to contact the other party. And they had at that stage, and I believe at the start of April, they had not. The services were not secured. So with regards to this category of complaints of me giving them instructions and they're bypassing them, that is quite clearly an element of complaint, because I explained to you at the start of this conversation that, look, I don't want them to be communicating with anybody without my express permission or authority, and yet they had already, and they had not even secured legal funding. They had not come on the register as being my legal representatives. So what right do they have to communicate with the other party in start of April when I had contacted them initially to make inquiries? So that's a point of complaint. That's a specific point of complaint, because and then subsequently I said it's a I had raised numerous written questions. Now, you will forgive me that if I've raised numerous written questions on the telephone call to you, if you ask me, well, which ones? I cannot tell you them because they're all written down, first of all. So you will have evidence of them. So in a general category of complaint is that I had given verbal and written instructions, which I can evidence. If I've given written instructions, then those are in an email, because my whole communication was restricted via email, number one. Number two, if they're verbal instructions, I have a copy of that, because I explained to you yesterday that I recorded all my conversations with the party. So the general complaint point from yourself is that, my complaints are that I had given, why had they overridden my instructions, whether verbal or written, and acted unilaterally without instruction? That is a point of complaint.
And I understand your point, obviously, but what I need to know what instructions that they've ordered. So the instruction, for example, that the firm didn't contact any third parties until legal aid was obtained, that's a specific complaint I can investigate, because when I request evidence, you can show me, I'd ask for evidence from you where you evidence that you asked them not to contact third parties, and I'd ask for evidence from the firm to tell me why it was reasonable that they did that.
Okay, so and then it would. So with respect, you understand, if I've given them over a time period 50 instructions, let's just say for argument's sake, all right. First of all, it would be highly unfair upon you for me to articulate them when I don't have my computer in front of me. I don't have that information in front of me. So like I said, I started in April because that's the start point. Subsequently, I've given them numerous instructions. So, rather than taking up more of my time and resources in order to give you specific, because they are specific, I just cannot recollect them at hand now to tell you specifically the terms. So that's... So that's why I've categorized them as in a general perspective, because if there are instructions, first of all, one of the things, I'm a prolific writer. So in these circumstances, because Sian, my understanding, remember I articulated to you that my understanding from the very start, even before I had contacted this particular solicitor's firm, my understanding was always the general understanding that it doesn't matter which solicitor I get, the services of the solicitors are going to be privately commissioned out unlawfully, illegally by the local authority. So that was my understanding, all right. So when I had approached the solicitor, I was very meticulous in order to categorize, record everything. All right. So, like I said, it's not the case that I'm now telling you I can't give you all the instructions. I give them numerous instructions. But it will require a lot of my time and resources. And number one, and number two is that they also have to disclose those emails to you now. So you will be able to determine and ascertain why through your investigation that, well, actually, I can see here on this particular date he has made this instruction, and I can see that I can't see any response to that instruction. So that evidence is available. It's just that at this moment in time, when you're asking me on the telephone, because this is only one category of complaint, and if I was to spend some time going through every single instruction, which effectively I could do so if I got on my computer and I can say on this day I did this, but all I'm trying to do is, as you can appreciate, Sian, I'm trying to rely on my memory alone, and memory is.
I appreciate it, but it happened a year ago, if not longer. So I appreciate you're not going to remember everything, of course. I do appreciate that. So what I'd probably say to do is, if after this call you want to go back and take the specific instructions that they didn't follow, because you see, if we put forward a complaint that, well, the firm didn't follow Mr. Hussein's instructions, we give the firm an opportunity to provide evidence to say, for example, this point that the firm didn't, you asked the firm not to speak to third party people until legal aid was obtained. We've been very clear on what that complaint is, so you can provide me specific specific evidence to say, this is when I told them not to do it, and the firm can give me specific evidence to say, okay, here's our evidence to say, well, we did contact him, but this is why, and we told him this is why.
Okay.
If we just say that they don't follow instructions,
No.
they're not going to disclose everything to me.
With respect, I mean, I understand what you're saying, but can you understand that the way you're saying things puts the burden upon myself? Yes. So I have to then articulate and so I have to then evidence them to you. I have to evidence to them. All right, and so that's one approach that you can take. Yes, but that would require the understanding that I, as a civilian, would have, I have procedures and policies and documentations in place that requires me to audit this information, all right, and that is an unreasonable expectation for any client to have. However, the added advantage is that I did not send letters or call recordings that I can make available, specifically made available to you. I could do so, but that would require an exorbitant amount of my time and resources. However, the alternative approach, like I said, rather than dealing with each specific instruction at a time and providing as a data point, what I'm saying is that should be as a collective, that Mr. Hussain is stating that he'd provided certain verbal and written instructions to you which were not followed. So that's taking a very short approach. Now the solicitor's firm can say, we don't know what you're talking about. We followed all his instructions. All right. So then you can turn around and say, well, it was incumbent upon you as a legal firm to have a record of all the instructions that you've received. So therefore, could you please disclose to me as an investigator all the instructions that you had received and responded to? So that puts a burden of evidence and proof upon them. And then therefore, once I receive that, look, these are all the instructions I had given them, because as you can appreciate, I am not required to document the instructions I give. I have done so as an extra thing, but ultimately the instructions I've given, like for example this call, I don't need to have this call recorded. I do so for my benefit. Then that my recording of this call should not be used. I should not be relied upon. Similarly, if I've given instructions from to a solicitor's firm, my aspect of giving instructions should not be relied upon, because I'm not required to document or audit them. However, the other part, the receiving party, the party as a solicitor's firm who are receiving instructions, because as you can appreciate, the solicitors must, by their business operations, receive instructions. They cannot do anything without instructions. So they must have a catalogue of instructions. So if I'm making the general term, yes, it is general. I've given you one specific example, all right, and I've explained to you that at this moment in time, it would be like unfair upon yourself for me to actually go through my own documentation, which is not really required of me. But as you can appreciate from the solicitor's perspective, they are by their very definition required to record certain documentations, correspondence, communication, and particularly instructions. So if I'm making the general complaint that I had given them numerous written and verbal instructions which were not followed by them, you can say that, well, okay, I can take that as a point and give that to the other party. They can quite rightly say, well, what is he talking about? Which specific instructions? And then at that stage, you can say, well, you did take instructions. So could you give us the audit list of all the instructions you took on this case? So they should have that list. So that will be that's already available, rather than I don't have the go on.
Just bear with me. So I understand what you're saying, I do, but we're not here to audit every communication. You've brought a complaint to us as a customer. So how we investigate complaints is you will bring a complaint to us. Like I said, we need specifics, what instructions. I appreciate you might not know what right now on this phone call because it happened some time ago. You had a lot of communication, so you've got an opportunity to go away and have a look. But what we do to investigate the complaint, for example, my next stage would be to confirm your complaints in writing. You will then provide evidence to prove that their service was unreasonable. For example, they didn't follow X, Y, Z instruction. Here are my emails, calls, whatever. And then it's up to the firm to prove the opposite. So we're in the middle. So the burden of proof is on you, but it's
No.
also on the firm as well.
But no, you're right. The burden of proof, obviously, I'm the complainant, and the burden of proof is upon myself. But at this moment in time, as I've explained, there's a category of complaint. So the category of complaint is you see you're redefining how things are to put me on the spot here. I've already proceeded to provide you with one example of providing instructions. That was the start of it. So I remember when the start of the instructions were. Now there were numerous instructions. It's not your job to audit communications, and it's not your job not to audit my instructions. Similarly, it's not my job to audit instructions, but it is the job of the solicitors to have an audit of the instructions. No.
I understand what you're saying, Mr. C, but if you're saying that they didn't follow your instruction, I need to see proof that
Yes,
what instruction
exactly.
it is that you
And
want
who
to
has?
follow and that they didn't
Yes,
follow.
and who has that information?
Well, you would have to provide that information.
No.
Because you put the complaint to us.
So, please, with respect, who has that information? That's not what I would have to do. Who has? If I've given instructions to the solicitors firm, who has that information?
Well, if you've given the instruction, you should have that information. You
Yes.
confirmed that you do,
Yes.
and the solicitors will have that information.
That's correct.
But
Yes.
what I wouldn't do
Mhm.
is ask the solicitors to collate all evidence that of every single communication
No.
that you've had with them.
No.
That's not how we would do it.
No. But to answer the question, who would have that information? I would have that information as the party giving the instructions, and the solicitor's firm would have that information. So there's two parties where the information you require is with two parties. It's either with myself and it's with the solicitor's firm. Yes, it's with two parties. Now there are two parties here. I'm the complainant. They're the respondent. Now, as the complainant, as I can explain, I have a pretty good memory, and my communications with you are right now without access to any computers. It's all done off memory. So I've got pretty good memory. All right, but my memory as a human memory is fallible, and I'm number one, and number two is that when I give instructions, it's not necessary for me to have those instructions auditable, because I'm the one that's giving the instructions. I'm a private citizen. Yes, I'm giving instructions. All right, so I do have that information. And where is that information stored? Where's the repository of that in particular piece of information? Not all my communications, the instructions that I had given. Where's the repository of that information? One repository is in my memory. Yes. The other repository is in maybe my email communications or my written correspondence. All right, that's another repository. But can you understand, my memory and my own private correspondence are not subject to formal formality. However, the other repository of this information is, I'm trying to explain, the solicitors have this repository of information, because every time they would have received instructions, what happens is that when you give somebody instructions, so for example, forgive this analogy, if I say I'm giving you instructions to go make me a cup of tea, all right, in order for you to take on the instructions, you have to then clarify, if I'm going to make you a cup of tea, how many sugars do you want? Do you want milk? So there's that whole aspect of clarity. So there's that aspect of clarity of information of receiving an instruction. But can you understand, if I say, all I need to say is for you to make a cup of tea, you're then having to record that. So in a similar vein, if I've given instructions to the solicitor's firm and I'm saying the fact that they've not followed those instructions, they are mandated by their very business operations to have the evidence is with them. So to say that you said the evidence is with you, well, no, the evidence with me is that I'm recalling on my memory as a resource, whereas it is readily available to them. So the approach that I'm asking yourselves to take is not to say that, oh no, well, we can't instruct them to collect the information. It's the way that they have organized that information, how they've received it, which they by the very process, they got paid to do that. So they got paid to take instructions. So there's a monetary value. So can you understand? They are financially incentivized to record and log things down, because ultimately they're not taking instructions from me and getting for free. So they have got legal aid funding. They are now taking instructions, and each instruction that they take or any piece of work that they carry out is being paid for. So it's being at public expense. So they by their very definition have to, at public money, have to have that record. I, as a private individual, are not being financially incentivized to give instructions. So I'm not in a position to record those instructions. So can you understand when I'm saying that? So all I can do is deal in general terms. They, as a solicitor's firm who have received public money, have to and have paid for systems, computer systems to be put in place. They no doubt have a contact relationship management system which is recording my calls. So for example, if I can say, look, I made many calls to them and they didn't answer my calls, as another example. Well, you can say to me, well, Mr. Hussain, I'm sorry, I can't investigate that because I need to know the day and the time that you called. And that would be unfair upon you because I'm making the general allegation that I called them on numerous occasions and they didn't answer my calls. Or they didn't respond to my calls. And you can say, well, I can't use that because that's not specific enough for me. What I need to know from you, I want you to evidence to me what particular day it was and what particular time it was that you called them. And I'm struggling with that because other than relying upon my memory, which obviously going to be infallible, and other than relying on the fact that I may have recorded them down, but they by themselves have a system in place that every time I rang up, they have to make a note that Mr. Hussain rang up on this day. So why would I have to give you, it would be unfair upon you to say to me that, oh, Mr. Hussain, one of your complaints is that you called them on numerous occasions, they didn't answer the phone, all right? So therefore, you tell me specifically each particular day that you rang up, and so I can log that down as a complaint. I'm sorry, that's not a workable solution. What I'm going to say is that, generally speaking, as this example states, that I made numerous calls to them, they didn't answer. So then you say the burden of proof upon them. What evidence do they hold, which they are mandated to do as a part of their business process, because they're a big organization, have many employees, they take calls and instructions all the time. So it is upon them to they have the repository with that information. They're not and you're right, it's not your job to collate any information, but it is their job because they are getting money, public money, money from the public purse through my legal aid. So they're in a position to evidence everything. I'm not in a position to evidence anything, so it would be unfair upon you to say, well, all right, I've got one complaint, all right, which is that at the start they contacted the party. Give me all the other instructions. I think that's an unreasonable expectation upon yourself as an investigator. And if that's something that's been insisted upon, then obviously this is a point of contention that I would have with you, with the way that an approach that you're taking, which would be something I would have to then escalate. What I'm asking yourselves to do is this: that I can only give you general categories of information, all right? And obviously, most clients of solicitors' firms are not at the same time recording everything that they're doing, all right, or evidencing it. In my particular circumstances, I am. But upon your, as an ombudsman, for you to be saying relying on, well, they've got their evidence, show us your evidence, all right? Because a client normally of a solicitor's firm does not collate evidence about their interactions with their solicitor. That's what the solicitor's job is. Otherwise, why would you have a solicitor for? So the information that you're...
Recall everything from memory. Absolutely not. Like that would not be possible. I couldn't recall everything off memory, from something that happened last year. Of course not. That's why I've said, potentially go away and have a look what instructions that you think you haven't followed and that you want to raise as a complaint. What I wouldn't do is go raise it as a complaint and pass it to the service provider, the solicitors, and say, well, Mr. Hussain said you haven't followed his instructions. Provide me a full audit of all your communications.
No.
And then go through all the communications to try and find the instructions. It's not a good use of their time, our time, or yours. If you have a complaint that you brought to us, you need to tell me what instruction it was that they didn't follow. So that example about not speaking to a third party until legal aid was obtained, that's very clear. That means that in the next stage of the investigation, you can send me, essentially an email or reference to a call or something. I can ask the solicitors, what was your response to this? What was your communication regarding any third parties? And then I can investigate that. But what we can't do is just pass through general complaints.
No, you can't. No, I'm sorry to interrupt. No, you can't do that. So what you're saying that you're not willing to do is that what you have to do. And I'll tell you why you have to do that. Because you're saying I'm not willing to do that because it would be an unreasonable expectation on the solicitor's firm to go through all the emails, all right, and go through all the instructions. And you're saying that would be unreasonable waste on their resources, all right? But conversely, you want me to go through all my resources. And the reality is this, that they're going to have to do this anyway. They're going to have to go through every single email, whether they do it now or at another stage. They're going to have to go through every single instruction, all right, that they have done. They have to do that. So, and the reason that they have to do that, and I would like to explain once again, is because they've taken public money. They are a publicly funded solicitors firm through legal aid, and so now when a complaint has been risen, it's a burden upon them as well, upon myself. So in the first instance, what I would like you to do is yes, they have to go through. If I'm making a complaint that so I said, look, there's a category of instructions that I've given, all right, and the complaint is on a general basis on the category. I've given you the first instruction that was failed upon. As I said, they have recorded that. I can only deal things with that as a category. They have to necessarily to have had that audited, because that's their processes. So for example, if I've given them instructions, that would be part of their business process to record it. All right, it's not part of my business process. So I think that this is where you and I are looking to differ here. And you're saying, ultimately, it's all to do with resources, isn't it? All right, so you would rather me take up my resources, which I'm not getting financially remunerated for, number one. And number two is that there's no obligation upon me to make anything other than the complaint to yourself. So for example, if another analogy I would like to give you, if I have been sexually raped by somebody, I need to state that this person did this action against me. I do not need to give evidence of that. And as you can appreciate, that's how the law works. If I make a complaint to the police, it's the police's job to gather that information. They can take a statement from me, that's fair enough. But with regards to court level evidence, that's up to the investigator to investigate. In a similar vein, I've made the complaint in a general term, all right. The solicitors firm have, by the very necessary to say, yes, we have. First of all, how do you know they already haven't collated as a business practice a spreadsheet of a date and time of all the instructions? You don't know that. You're assuming that because you're saying that they're gonna have to do all the, you're not working for the solicitor's best interest. You're meant to be arbitrary. And so when I'm saying to you that, look, I can give you that there were numerous written, verbal complaints, written and verbal instructions given to the solicitors firm. I can effectively evidence that. But at this early stage, I'm dealing in abstract terms because I would like the other party to respond. Now, for example, if I think which evidence I'm going to provide you with is that subsequently you were told me at this stage, yeah, you're not asking for my evidence. At the stage when I'm providing you with evidence, because I've got all the recordings, now that may be like 30 hours of recordings, you would like me to do your job for you and go through the recordings and pick out these things. But that's what evidence I'll be giving to yourself, and all I can do at this stage is make allegations at a higher level rather than dealing with specifics. So I've been trying to be quite specific in certain regards, particularly with regard to the first complaint. Now that's taken at length and time to tell you this. If you want me to, then what I'm going to do is that if you're refusing to operate in this manner, then unfortunately what I'm going to do is that I will then, if that is the case, because obviously I'm going to have to go through all this stuff at some stage anyway. If I go through the next instruction, I will give you that instruction. But then at that stage, you've already received the evidence. So, at this early stages, all we can do is speak in abstract general terms. That, look, this is the category of complaint that Mr. Hussain is saying that you're not providing within some information, right? And then they will respond. Mr. Hussain is saying that he's given you instructions, you've not followed those instructions. If they come around and say which specific instructions, then at that point I can say, well, what instructions do you have? But I think it's like I'm trying to work with you here, because obviously I feel that if my allegations, general allegations, are true, that this solicitor's firm, and not just only this solicitor's firm, many other solicitors' firms are acting in their own personal financial interest over the duty and care that they have to the client, and fraud and malevolence is taking place, which has effectively resulted in my mother's murder and death, then these matters must be taken seriously. And so all I can say is at this stage, when we're looking to have a conversation, and I think our time is running out again, is that I can only at this stage tell you from my perspective where I'm at and what's been happening. Now I've got up to July and August when things have failed, and then obviously there's October and November what happened, and December, and then up until January that I wanted to discuss with you. And then it's upon yourself as an investigator to say, well, Mr. Hussain has given us all this information. Some of the things I can see that I can agree upon that is something that we can investigate, and this this is something that we can't investigate, and that's something upon yourself. It's for me to say, well, look, these are the specific things that you should be investigating, and so that's what I'm giving you. It's basically it's a cop out, in my opinion. All right, it's a cop out on your part, and basically it's a placing the focus upon myself. I've raised a complaint. It's a very legitimate complaint. I have ample evidence to do so. But what I will not be doing is equally is if you're saying it's unreasonable for them to collate this information at this stage of the situation, when I'm trying to tell you general terms, it's unreasonable for me to collate that information. Should at some stage where the solicitors come back, have collated this information and provide me with evidence, all right, or through this investigation that they did comply, I will then look to rebuttal them through my own evidence. But can you understand that? First of all, I'm put on the spot here. I'm trying to. It's a very complex situation. It was something done a long time ago, and I think that it's unfair upon yourself to, in this call today, ask me to list down all the specific instructions. I give a first instruction. I then proceeded to tell you that these are some of the other complaints I had. I had recorded things myself, but the thing is, at this stage, as an independent ombudsman, as an investigator, you understand that not everybody's like me. Not everybody records things. So it concerns me of the approach that the ombudsman is taking, where they say, well, the burden of proof is upon you. All right. Of course, the burden is of proof upon me, but can you understand, as a civilian, it's also unreasonable. The only thing that you can be reliant upon is my memory. Because that's all a private citizen needs to do. As a private citizen, I need to pick up the phone, give instructions to a solicitor's firm, and do everything off memory. And then obviously I can recall things off memory.
Just always say this to say, but I'm not asking you to right now recall things off memory. If you can, fantastic, I can note it down now. I understand if you might need to go away and have a look again. And I appreciate if you turn around to me and said, I actually have no emails, no records of these calls, no letters, and ultimately you couldn't provide me any evidence, and that makes it substantially harder to investigate. We do ask every customer that comes to us to provide evidence for their complaints. Now, in terms of following instructions, I do need them to be specific. Like the next stage would be, I would speak to the firm, discuss your complaints, give them an opportunity to provide comment, and the next stage would be my evidence request. What I'm not going to do is ask for the firm to send me every single piece of documentation that they've got in terms of instructions. They need to know what instructions you're disputing and they didn't follow.
So just in this conversation, you've just said to me that it's not expected of me to have any emails. It's not expected of me to have any letters. It's not expected of me to have any call recordings. You said that, haven't you?
Yeah, and people do come to us without evidence, unfortunately.
Okay, all right.
It's very hard to investigate. Sometimes we can't investigate.
Okay, all right. At this moment in time, that's a position I would like to hold. That I don't have anything, and I would like the solicitors to give me everything. So they don't need to give you anything. They need to give me everything that they hold. Because, like I said, that they are obliged, they are legally obliged. They're holding that information because they got paid for it. So then, now that they got paid for it, hand that evidence to me so I can present it to you. So then I will go through there. So they're not required to give you anything, but they are required to give me something. So that's a way forward. If you wouldn't be, I'm not going to be relying upon my memory. I'm not going to be relying upon my own domestic policies and procedures of recording. I'm at this stage saying that I have no evidence, or no emails, no phone calls, no nothing. They do. So in order for you to investigate, they need to provide me with that information so I can assist you with your investigation.
So what you need to do is request for that evidence from them. I wouldn't ask them to provide you with every single communication. You would need to ask them, and you've done that during our subject access request.
And they've not complied. So they're not complied. So they're basically, so at this moment in time, how I would like to proceed is that you can just write to them and say, look, Mr. Hussain saying that provide him with everything, and then he will provide me with further points of investigation. I'll do that. But one thing, like I said, that I don't want people to be reliant upon who I am. There's no expectation upon me to have any evidence. Is there? Let's agree on one point. There is no expectation upon me to have any evidence, is there?
Well, I would expect you to have some evidence.
No. Generally speaking.
If you didn't have any evidence, it's likely we wouldn't be able to investigate the complaint.
Okay. Generally speaking, as an ombudsman, you've not designed your policies around me personally, have you? The general policies. And you've just said to me earlier on in the conversation that often people can raise a complaint to you and they have no evidence. Yes?
And in those cases, we're unable to
No, you're not unable to investigate, because earlier on in the conversation we've agreed the fact that if there are two repositories, who has that information? Either me, who has the evidence. Either I have the evidence, but or I may or may not have the evidence, but who does have the evidence is the other party. Yes? So, it's not the case. So, just to recap, yes, as a member of the public, I'm not required to have any evidence. And therefore, just because I don't have any evidence as a member of the public, does not mean the fact that you cannot investigate. Because if, for example, the other party didn't have any evidence as well, if they didn't have any evidence, then you're able to say, well, we got nothing to work upon, because the complainant has no evidence, the party being complained about has no evidence. We've effectively got nothing to work upon. All right. That's the only time that you can have that. You can say that. Under these circumstances, I'm claiming that I have nothing. They have something. All right, and therefore you can still investigate because they have evidence. All I have is allegations. So as a complainant, I'm not required to provide evidence, but I'm required to provide an allegation. That's what a complaint is. A complaint is allegation based. I'm alleging that they've done all this stuff. All right, they are evidence based. So right now, I'm not required to provide you or anybody else with any evidence. All I'm required to do as a complainant is make an allegation. It's alleged. All right, everything I've.
Your complaint.
Yes.
But what I've said is we cannot confirm a complaint that is just that the firm failed to follow your instructions. We need specifics of what those instructions were.
First of all, if this is the situation, then you're wrong. You as an ombudsman are wrong. All right, because a complaint, what you need to do is record my allegations. All right, not my evidence. So I'm alleging things. All right, the whole point of the investigation is, see, when the investigation starts, then it's an evidence-based investigation. The complainant at this stage is making an allegation. So I'm alleging things. All right, I'm not alleging.
And I agree, but you have to be clear in what you're alleging.
Yes, I'm very clear. Yes.
Instructions.
Yes.
You have to be clear in what instructions you haven't followed.
Well, fair enough. That's fair enough. But like I said, but then what's the point of the evidence-based? If I'm providing you with evidence at this stage, I think this is where you and I maybe differ. At this stage, I'm not required to provide you at this stage. It's not the case that I won't do later on.
That's correct.
Yes.
You don't have to provide the evidence at this stage. What we need to do at this stage is confirm your complaint. What I've said is I cannot confirm a complaint that is just the firm failed to follow Mrs. Dane's instructions. You have to tell me which instructions they failed to follow.
All right. Just hold on 1 second. At this stage, I've made the allegation that they've been failing to, in general terms, failing to follow my instructions. You're saying, so that's an allegation.
You're breaking up a little bit.
Sorry. So that's an allegation. All I'm required to do is provide an allegation. All right. So, and you're saying, well, go through each.
At this stage, we're just confirming your complaint.
Yeah, the complaint is an allegation, isn't it?
Yeah, what you're alleging is
yes.
Done.
What I'm alleging, so that's an allegation. So all I can do is allege that. All I can make is allegations. All right. And it's your job as the investigator to investigate allegations, not specific points of the allegations. So that's why I would say allegations by their very nature are general. So I've proceeded at length to provide you with the specifics of a particular incident at length. All right, but the whole point is that at this stage, I'm making allegations. Through the investigation process, you will determine if there's ample evidence to support the allegations to conclude that the complaint is valid. That's how I would think that the.
Sorry, just bear with me to say that the signal broke off there. I just missed that.
Okay, so at this stage, what I would anticipate is that. So at this stage, what I would anticipate is that I'm making an allegation. Your job is to investigate the allegation based on facts to determine if my allegations are upheld, so that the complaint is valid. So whether my complaint is valid or not can only be determined. So the whole point of the complaint is to see whether it's a valid complaint or not a valid complaint. In order for it to be a valid complaint, you have to investigate the allegation. So the allegations I'm making to yourself are in general terms. Then when it comes to evidence-based, when they're providing evidence, I will provide those evidence. But ultimately, what I feel that you're trying to do is you're trying to get me to provide you with evidence. I'm not in a position to provide.
I don't need any evidence at this stage.
Yes, you do. That's what you said. If you're asking for,
I just need you to confirm to me what instructions you think the firm
with respect.
I understand you can't remember right now. Absolutely, I'd be surprised if anybody could remember every instruction. But you brought a complaint to us, so you need to tell me what instructions were followed.
No.
If you need a minute to go back to your emails or calls, I appreciate that, and come back to me. But I need to know the specific instructions. Otherwise, I can't investigate the complaint.
Okay, well, you already have one. You already have one specific aspect of the complaint. You require no further evidence of that, do you?
No, so exactly. We've confirmed that because that's a specific instruction you said the firm haven't followed.
Okay.
So we confirmed that complaint. If there's others, then that's fine.
Okay, all right.
Me at a later date with
Okay,
them.
all right. Well, yeah, well, that's a way to proceed forward. But like I said, the approach that you're taking effectively is I disagree with the approach that you're taking, because at this stage I'm not required to provide you with any evidence. Can we be clear upon that? I'm not required to provide you with any evidence. But what I am required, in order for the complaint to be investigated, is to provide you with an allegation. Yes, and the allegation. Yeah. So the complaints are allegations, aren't they? So allegations don't need to be specific.
But what we can't do, Mr. Sian, is just that at this point, I understand that you brought your complaint to us, we're investigating it. What we need to do now is confirm your specific points of complaint. So when I write out to you and the firm, these are Mr. Sian's complaints, and the evidence I need to see. I need to be clear on what they are.
You know, unfortunately, we're running out of time now, and like I said, we can continue this conversation at another time, because I don't think we've made much progress here. But I proceeded to explain to you the seriousness of the issues. I've spent a considerable amount of time. These calls are being recorded by yourself and by myself. Okay, I would like to proceed on this complaint. I would like to have another opportunity to see if we can deal with more specific, because the aspect of them not responding to my instruction is only one element of further allegations that I'm going to be making, all right, that need to be investigated. And so I don't think I've been afforded ample time to have a further discussion with you. Now, unfortunately, I have other commitments, so I can't continue this call. Would it be acceptable for us to re-continue this conversation at another time?
Of course, I can speak with you again tomorrow, Mr. Sian.
Tomorrow, it's going to be a bit difficult for me on tomorrow. It's going to be very, very difficult for me. Would it be possible on Monday?
Yeah, of course, Monday is absolutely fine. What time is best for you?
Monday, can we say about how, let's say 2 o'clock?
2 o'clock, that's absolutely fine. I'll put that in my diary.
And I would like to limit it to no more than 2 hours. I mean, I hope we won't need the 2 hours, but if you go past 2 hours, I won't be able to continue past 2 hours.
All we need to do, Mr. Hussain, is confirm your complaint. So it might be worth in the meantime thinking about what I've said. We can only investigate specific complaints. I need them to be specific. Otherwise, and it might be worth, in terms of, we've not really spoke about what you're expecting from this complaint. So what if you've got a quick, little bit of time now, so you just quickly tell me what you're wanting from this complaint.
Well, what are you willing to provide me with?
Well, most complainants come with complaints in mind of what they want from the firm, what they think the complaint, how they think it should be dealt with.
Okay, well, like I said, if I'm raising a complaint, the net benefit to raising a complaint is also to the organizations, because that gives them an opportunity to make a better service for them. Yes, so they can make more money.
Of course.
Yes. So do you understand the net benefit of me complaining, if it was not malicious, if it was simply a failure on their part, I can set up a solicitor's firm tomorrow, all right, give a really bad service, get complaints, and then use those complaints to provide a better service. So ultimately, the net beneficiary, they're basically exploiting my time. Like this time, like for example, with respect, and the reason I get frustrated is that, can you understand, in yesterday's conversation, you were required to tell me that this call is being recorded. All right, and I told you that I'm recording this call. Can you understand there's a fundamental difference between you and I in this conversation? Why are you required to tell me that the call is recorded and I'm not? Do you understand the difference?
Well, I'm just trying to discuss what you wanted from the complaint in terms of a remedy.
No, just hold on 1 second. The difference is because you're right now being paid for your time, aren't you? You're an employee of an organization, your time is being paid for. All right?
Correct, yeah.
My time is not being paid for. So I'm trying to. This is my personal time that I can be spending somewhere else. So that's why the system should be geared towards advantaging me, because my time is not being remunerated. The solicitor's time is being remunerated. Your time is being remunerated, and that's why, hence why, the focus should be on the citizen who's giving up their personal time in order to effectively make the solicitor's firm better. Now you're asking me what remedy would I require? But obviously there's restrictions on what remedy that you can provide me with. If my complaint is upheld and the solicitor's firm are effectively going to have a net financial benefit because they are in a better position to provide a better service, then quite clearly my time needs to be remunerated. No, that would be the only logical reason. That would be only the logical outcome of what I need to be financially remunerated. All right, so that's one option. But ultimately, if they made a mistake, they recognize the mistake. Then what my expectations would be, maybe what I don't know, how else would it be benefit me? Because I'm basically effectively giving up my time in order to deal with somebody else's incompetences. All right. So you tell me what remedy do you think I should be seeking? Because I'm giving up my personal time. This time I can be spending doing my own things, making money, doing my own job. I'm giving up my time in order to deal with, assuming that the solicitor's firm were either malevolent or incompetent. Let's just assume that they were incompetent. All right, that this is the complaint is upheld because of their stupidity and incompetence. All right, should I pay as a private citizen? Should I be paying for their incompetence? No, I shouldn't be paying for their incompetence, should I? All right. If they anybody, like I said, I can just any Tom, Dick, and Harry can go register with the solicitor's regulatory body and just say, "Oh, I'm a solicitor," provide a poor quality of service, and get the public to effectively feedback from the public in order to improve the services. You asked me the question of remedy. I, at this moment in time, do not know what remedy I require. Obviously, they have failed to take instructions. What I'm trying to do, rather than remedy, is have a determination. Was that determination malevolent or incompetence? What is the reason that they did this? That's all I'm trying to determine. So my expectations are, I want to understand why you've done this. Was it right or was it wrong? If it was wrong, why did you do it? Does that?
We might, obviously, in the investigation, we might find that the service is unreasonable. That's a determination, we can make in an investigation whether the service is reasonable or unreasonable. But we can't explain why the firm has done what they've done. You may never get that explanation.
But they can though.
That the service is unreasonable.
No, but they can answer that question, can't they? If you, for example, we're just giving this one example where I've given them instructions, they've disregarded those instructions and they've gone away and talked to the other party. You may, I'm not saying that this is going to be the case. You, through your investigation, say that's unreasonable on their part. You make a determination saying that, we feel that was unreasonable on the part of the solicitors. The solicitors then can say that, I can then ask the solicitors, give me an explanation. Look, here's a third party, Ombudsman, saying that you acted not reasonably. So you tell me, why did you do this? So at least that gives me an avenue to say, a remedy. I want to know why you've done this. What was the reason for it? What was the cause of it? Was it incompetence? And if it is incompetence, all right, what's the remedy that the solicitors can provide me with? They can give me a formal written apology. All right, that's one remedy. It's not that saying I would accept that apology, but that's a remedy. All right, they can look to find. Ultimately, it comes down to finances, isn't it? They can financially remunerate me for the distress or the loss that I may have covered, because under these circumstances, effectively, by them not delaying having a 6-week delay, effectively exposed me to being incarcerated and imprisoned, going to jail and losing my liberty, having an adverse effect on my family. So you understand, how do you compensate for that? So then I can then pursue my own litigation action, saying, look, I've raised a complaint with the Ombudsman. They have concurred with me on these points. All right. Now, with regards to compensation, I'm not asking the Ombudsman to compensate me, or I'm in a better position to take legal litigation action, saying, well, here's a third party who's supposed to be unrelated to the situation. They have concurred with me that the solicitor's firm have acted unreasonably. Now, the damages that in an exceptional circumstances the Ombudsman can provide me with is nowhere near the damages that I have incurred, because their maximum is £50,000. I maybe suffered £200,000 worth of damages. But that is not something that you would be able to enforce or put through. That's a burden upon myself. So my expectations at this stage are to have my allegations validated. That's all I'm expecting from you. Are my complaints lacking, complaints or allegations lacking validity or not validity? That's all my expectations are coming to yourself. As a third party, impartial person who's going to investigate, look at the evidence, I want you to even make the final decision I want from yourself is that your complaint is upheld, your complaint is not upheld. All right? That these are invalid, you're just making stuff up. These allegations have no foundation. So once you make that conclusion, it's upon yourself then to say, well, in order, we feel that the solicitors firm are so bad that we're going to penalize them. I'm not even asking you for penalize me. That's your decision. I'm not going to ask for that. At this stage, all I'm looking to do, approaching yourself, is from a third party to investigate my allegations. They will provide the evidence, I will provide my evidence. The outcome I'm looking from yourself is to say, your allegations, all right, through the investigations are upheld, and therefore your complaint is valid. That's it. Or is invalid. Is that clear about my expectations?
Yeah, but you just want us to carry out the investigations to whether the service is reasonable or not.
No, that's not the way. I don't care about their reasonableness. I care about my allegations. Are my allegations substantiated through your investigation? That's all I'm trying to say. So I'm at liberty to make any allegation. I can make an allegation today. I can say to me, look, you've been racist to me on the telephone. That's an allegation. You can't stop me from making an allegation. I can say right now that over the course of this telephone call, you've been racist towards me. That is an allegation. All right, I can make that. Look, forgive me, I'm not saying that, but that's an allegation. I then can report that to the police. The police have to take that as an allegation. They'll have to investigate. They can review this call recording. They can say, look, you recorded this call, Mr. Hussain is making this allegation. Let's review the call. The police will say, no, actually, there's no evidence of that. All right, that's an allegation not upheld. However, if the police investigate and find out that, yes, you did say something racist to me, all right, they can take their own action, but I'm in a better position to take civil action against your organization for being racist towards me. Can you understand? Allegations by their very nature are not evidence-based. All I need to say is this is what happened, this is what somebody did. So ultimately, that's why I'm coming to you and saying, look, these are some of the things that they've done to me. All right, I'm a aggrieved party. I've got grievances. Some of those grievances are substantiated as allegations. So any grievance that I have is alleged. All right, it's not. It only becomes a fact once you've concluded your investigation, which I'm looking to help and assist you with. All right, so you can conclude. So my allegations are upheld, or my complaint is upheld through the allegations, because I'm an aggrieved party right now. As an aggrieved party, I feel that the service that they've provided is malevolent. So one of two things is happening. Either as an investigator, you can make you're never going to be able to make a determination whether they acted malevolently or incompetently. What you can do is say that, yes, under these allegations that we've investigated, we've concluded that the complainant was upheld because there was a failure on these specific points. I understand that. But ultimately, my perspective, you've asked me what I'm expecting. I'm of the opinion, all right, that the solicitors have acted malevolently, deliberately acted fraudulently and criminally. You cannot investigate criminal matters. That's something that I must pursue. But at this moment in time, all I'm looking to do is crystallize my complaints through making allegations and going through this process. It's a process. We have to follow it. The investigation is now started. You're an investigator. I'm looking to assist you as best as I can. I'm not trying to be obstructive or confrontational with yourself or trying to be obtuse. I'm trying to assist you as best as I can. But understand that this is a taxation on my resources. And when you're asking me for specifics, I can provide those specifics. But I'm in a catch-22 situation because ideally the other party have this evidence. So for example, alternatively, in order for me to get the evidence from the other party, I can instigate legal proceedings, and they are then forced to provide me with a disclosure under civil procedure rules of data that they hold. The bottom line, Mrs. that, and I look to end the conversation today with respect, is that I'm not expected to gather and retain evidence that you require. However, the other party is required by the very business processes to evidence everything that they're doing, because they're gathering that evidence at public expense through the legal aid funding. So they already have evidence that they should be sharing with us, all right, that they are required to share with you and myself. So I'm not required to have any evidence. I'm not required to share any evidence. Not that I'm saying that I will not be. I will be, obviously. But at this stage, they do have that evidence. So they have all my instructions. So if you're asking me for specific instructions, and they have the evidence, they've got a list of all the instructions that they received that they didn't respond to, and those instructions were given to them by email, and they're not giving me that. So that's the first complaint I had. Anyway, Miss, I think I've taken up more of your time. I would like to end the conversation now and look to re-engage with you on Monday at 2 o'clock.
Yes, to Monday 2 o'clock. That's absolutely fine, Mr. Hussain. Thank you.
Thank you. Goodbye.